All right. So I think we can get started, and we'll have the rest of our attendees trickling in. So hello and welcome everyone. Thank you for joining us for today's webinar on the criminalization of environmental protest. I'm sure most of you that are listening in today will know how timely and urgent this topic is. And we are very excited to be joined by four academic speakers who I will introduce in just a minute, who will tell us more about what criminalization means and the forms it takes and how it shapes environmental activism in different parts of the world. So this webinar is being organized by the Interdisciplinary Global Development Center, also known as the IGDC, based at the University of York in the UK. My name is Sabha Joshi, and I'm a lecturer at the Department of Politics and International Relations and the Deputy Director of the IGDC. So just to tell you a bit about our center, the IGDC is an interdisciplinary research community which promotes research on equitable global development and brings together researchers from across the humanities, social sciences, and natural sciences, both within the university and globally. So to become a member, you can visit our website, www.york.ac.uk/IGDC, and you can remain informed about various events and activities. So before I introduce our panel today, I just want to mention a couple of housekeeping points. First of all, this session is being recorded, but only the video and the audio of the panelists is being recorded. So attendees, your mics are muted and your video is off, so you won't be recorded. So to ask questions, please click on the Q&A button, which you will find on the bottom bar of your Zoom screen. The panelists will answer questions towards the end of the session, but you can submit questions as we go along. So now I'll just go ahead and introduce the panel for our webinar today. So we're joined by four panelists. So first we have Dr. Graeme Hayes, who is a reader in political sociology at Aston University. So Graeme's research focuses primarily on environmental social movements, civil disobedience, and the criminal trials of activists for their participation in nonviolent direct action. And he's authored several books on these themes and has formerly served as joint editor for the journal Environmental Politics and former editor and editor-in-chief of the journal Social Movement Studies. Then we have Dr. Stephen Cammiss, who is an associate professor in law at the University of Birmingham. Stephen's research focuses on the operation of the criminal justice process and in the broad field of law and language. And his current research is in an interdisciplinary project on the criminal trials of activists. And this has included observation of a number of high-profile trials, such as the trials of Extinction Rebellion, Insulate Britain, Just Stop Oil, and Palestine Action activists. And then we have Dr. Roxana Pessoa Cavalcanti, who is a critical social scientist and whose research interests lie at the intersections of decolonial theory and feminist activism. Roxana is a senior lecturer at the University of Bristol and is the author of a volume titled A Southern Criminology of Violence, Youth and Policing, which was published in 2020. And she's the co-editor for the Journal of Gender-Based Violence and the co-founder and co-director of the Feminist Cities Collab. And last but not least, we have Dr. Oscar Berglund, who is a senior lecturer in international public and social policy at the University of Bristol. So Oscar has extensively researched climate change activism and the criminalization of protest and activism. And he's co-authored a volume called Extinction Rebellion and Climate Change Activism, which was also published in 2020, and is one of the co-editors of the journal Policy and Politics. So with that, I will just hand over to our first pair of speakers for today, Graeme and Stephen, who will be presenting together a recent project that they have been working on. So Graeme and Stephen, over to you.
Okay, thank you for that very nice introduction, Sabha. It's a pleasure to be here to speak to everyone on this topic. So we're going to speak on silence and climate disobedience in the English courts. So I'm Stephen Cammiss and my colleague Graeme Hayes will speak around halfway through. And this builds upon the work that we do on observations of the trial of activists. And we'll talk about that at the moment, and then we're going to look in particular at one trial, or a couple of trials actually, if we've got time to. So if you just skip for me, please, Graeme. So the broader project that this presentation is based upon is around our ethnographic observation of the criminal trials of what we describe as non-violent direct action and disobedient activists. So we're interested in their experiences, and it's a project that works from the ground up. We want to place central to what we do the experience of activists and how the legal process impacts upon what they do, and the options that they have available to them. And our starting point in our early work on this was a Foucauldian perspective that looks at the trial process as one that's productive, one that produces notions of what is legitimate in relation to political activism, and also what is illegitimate and what criminalises. So in relation to that sense of legitimacy, we're interested in what legitimate action looks like and what illegitimate action looks like. We're interested in who can undertake legitimate action and who can't, in other words, what they look like. And also we're interested in the legitimacy around what arguments can be made in courts. And we want to really focus upon that today as part of this concept of silencing and what we mean by silencing. We just want to talk a little bit about the context, given the overall aims of this webinar and this series is about the criminalisation of activism. We want to put what we want to talk around trials in a broader context. So we see in England and Wales what we would describe as a shift to an increasingly repressive response. And where that fits with our work, in particular, if we look at the Police Crime Sentencing and Court Act, that placed the offence of public nuisance on a statutory basis. And that's been incredibly important in the trials of activists because the police and the CPS are increasingly relying upon public nuisance as a go-to charge. And similarly, we see in the Public Order Act 2023, the creation of the offence of interference with key national infrastructure is again an offence that is increasingly used against, in particular, climate activists and the activities that they engage in. But and I think we couldn't, even though we're not going to talk about it centrally today. We do observe the trials of Palestine Action activists, and we couldn't not comment on the recent prescription of Palestine Action as a terrorist organisation as very much part of that shift to increasingly repressive response by the state. I think what most academics do when they look at this idea of repression, look at policing and the creation of offences. But I think where we are slightly different is we look at what this means in the trial space and how that works. So if we're going to talk about the trial space and think about the trial space, that we have to ask the question first and foremost of what is the trial for? Why do we put individuals on trial? And we've asked a question on the slide there on what basis should a trial proceed that's linked to that question. And for us, we see the trial as being more than about mere adjudication. It's not simply about the finding of guilt or the declaration that someone is not guilty, but rather we follow the work of the legal philosopher Anthony Duff, who says the trial is a process that aims to hold defendants to account. It aims to hold defendants responsible for what they've done in terms of their acts as criminal acts being public wrongs. So central to Duff's account of the trial is the idea of a criminal offence as being a public wrong, where an individual doesn't just harm another, but does so in a way that impacts upon all of us as a collective. It's a breach of our collective norms. And we think that's really important in relation to activism, because activists deny centrally that what they do is a public wrong. They deny that. Instead, they claim to be acting on behalf of the community. They claim to be engaging in a democratic act where they as citizens are acting to highlight injustices or to ask others to correct injustices. And we think that leads to important implications for the way that trials should operate. So you could switch, please, with me, Graeme. Oh, Graeme, can we? Thank you. Yeah, so what we argue for in a recent paper in the Oxford Journal of Legal Studies is that the trial of activists should work in a way that respects activists' philosophical beliefs, in particular their Articles 10 and 11 rights. And we place this under what we describe as the integrity principle. And in the integrity principle, activists should be able to explain and justify their actions, but should be able to do so in meaningful ways and in law. And what we mean by that is that activists should have meaningful defences that are available to them. And therefore, they should be able to seek to persuade the court of their moral rightness, that they are acting as citizens, and that activists should not have to seek forgiveness or deny their acts. They should not disassociate their acts from their beliefs and should be able to explain that they are correct. And we describe this as the integrity principle. And we want to talk and think about how this impacts today in relation to silencing and the process around silencing. So again, drawing upon an earlier piece of work, we think that what's happening in the court space at the moment, both at first instance, but also from appellate jurisdictions as well, from higher courts, is that the courts are rejecting this idea of the integrity principle. That is that potential defences, such as necessity and lawful excuse, have been systematically restricted or removed by the Court of Appeal in ways that mean defendants are not able to actively explain their motives and not able to actively explain why they did what they did. So our next slide, could I have the please, Graeme, is, one I'm not going to speak to in any great detail. It just gives a sense of what's happening. So we've started there the case of the DPP and Ziegler that went to the Supreme Court in 2021 as arguably the high point of defendants being able to explain their motives in court. So that was a case around an obstruction of a highway outside the EdExcel Centre in London around an arms fair. And the Court of First Instance, and this was upheld by the Supreme Court, held that the defendants it should be able to rely upon a proportionality assessment in relation to their Article 10 and 11 rights as part of lawful excuse. In other words, if a conviction would be an adverse interference with their rights, then they would have a lawful excuse that would excuse their protest. And the defendants in Ziegler were acquitted. And what we see in all those other cases, arguably, is a retreat from Ziegler. And Ziegler now very much stands alone as one, as a defence for the offence of obstructing the highway. But other offences, such as public nuisance or interference with key national infrastructure, we see that in Sati and Oars in the last case, that proportionality assessment is not required. It's seen as part of the standard offence. In other words, defendants can't explain why they did what they did. And that has serious implications for silencing. And at this point, it's time to pass over to Graeme.
Yeah, just to pick up on that, we're talking about why defendants can't explain to the courts why they did what they did and develop a legal justification for that within the court, which is our argument about silencing. How does it take place? And what that means for defendants who are taken to court, who are prosecuted. How do they respond to this? Stephen said at the start that we see the trial as a productive space. So this isn't just simply a question of straight repression. There is also a space here for activists who are defendants to develop counter strategies or counter tactics in court. So we want to look at how they deal with this and what this adds up to. And I'm going to focus on two trials, which are both of them, I think, quite familiar. The first is the soup throwers, so Phoebe Plummer on the left and Anna Holland on the right, who threw soup over the protective glass over the painting Van Gogh's Sunflowers in the National Gallery in October 2022, and who had expected, when they were taken to court for criminal damage, who had expected or planned to be able to mount a lawful excuse defense, one which would allow them to contextualize their action in law and argue effectively either that they were acting to prevent a greater crime, or that their Article 9, Article 10, Article 11 rights enabled them to act in this way, and that their action was a proportionate use of their, what we loosely call their protest rights. When they get to court, the judge here, rules that, in fact, that they don't have access to a lawful excuse defense, and he does so on two grounds. One is the quite familiar ground at this point, that that the charge is so severe that proportionality assessments do not need to be made, because if they are convicted of the offence, then it will be axiomatically more serious, more significant than the protections that might be offered by their protest rights. So he rules out a lawful excuse defense, but also uses a second ground. And I think this is really important to say that we're constantly in a space here of entrepreneurialism, that the judge also rules that the act itself was violent, and arguing that he sees no difference between throwing the contents of a can of soup over a person and throwing the contents of a can of soup over an object such as the painting. And therefore this is an assault, and therefore ipso facto an act of violence, thus taking it outside of potential European Court of Human Rights protections for protest. So within this, what is it that activists do? Well, they have to be able they're able to defend themselves, they're able to talk in court. When we talk about silencing, it doesn't mean that they don't have a right to speak. We talk about silencing, about the meaning of the defences that they're able to put forward. For a criminal damage charge, the Crown, the prosecution, has to prove that either it was intended or it was recklessness. Otherwise, it would just be accidental damage. So we see activists developing in this trial two quite typical responses. And we see that the first defendant, Anna Holland, who is the on the right in the initial image, taking a strict legal defense. In other words, it wasn't reckless, it wasn't intentional, nobody thinks about the picture frame. And within 17 minutes, their defense barrister asks Anna Holland 7 times whether they were thinking or talking about the picture frame in the run-up to the action. And Anna simply replies, no, I was thinking about climate change. So in other words, they are able to mention climate change, but they're not able to develop an argument about it. It is a strict legal response to this, and one which is well suited to having a barrister in court, because this is a defense in law, but is one which isn't about the wider political situation or the reasons for their action. It's decontextualizing, depoliticizing the action. The second defendant, Phoebe Plummer, acts very differently, develops a very different type of argument, which is an appeal to the jury to take a decision to acquit them on the basis of their conscience and not on the basis of finding them not guilty in law. The jury still has the right to act on the basis of conscience rather than to decide in law. And so Phoebe Plummer simply says, did we intend to cause damage to the frame? Of course not, but that's it, they're done with that, they're off. I intend to shine a light on the connection between the cost of living crisis and the climate crisis and so on. And therefore introducing context and politics into the court sphere. So it's still finding a way to bring that context into the court, but it's doing it outside of legal defenses available. Why did they act like this? Well, they felt that there was a strong chance that even if they were found guilty, they would not be sentenced to prison. Anna Holland, for instance, had no criminal record prior to the action. In fact, they were found guilty and they were sentenced to 24 months and 20 months in prison, respectively, which is, I think, shows the extent of this change in what's been happening in the UK over the last 5 years or so. What about the second case? This is also same court, July 2024, the same judge. And here we've seen a very different development of a response. It's what we refer to as truth-telling, and really is something which was developed by Just Stop Oil in the wake of this changing response of the state, and particularly the charging of public nuisance. And this is for actions again in October 2022, occupation of gantries over the M25 motorway, charged with public nuisance in a way that activists would doubtless not have been prior to the PCSC or prior to the Insulate Britain campaign of 2021. And in this case, the activists believe themselves that they would most likely go to prison. How do they respond? What does truth-telling mean? Well, it means non-compliance. It means insisting on telling the truth in court and not submitting to the directions of the judge as long as they are not able to give their truth in the court space. So these are my notes from, both of these are from observation in court. These are my notes from the court that day when Cressida Gethin, one of the five, was giving their evidence. And you can see this refusal to submit to the directions of the judge, to be quiet, to not speak. And the defendants argued that they should have the same time as the prosecution had in order to be able to make their case. In fact, they're given 20 minutes each, whilst the prosecution takes 6 hours. And you can see what happens throughout to all of the defendants in the trial is effectively the judge calls in the police, has them taken down to the cells. And at the end of this, they're found guilty and they're sentenced to 5 years and 4 years in prison, which has been reduced on appeal, but still retain 4 years and between, I think it's 26 months and 3 years in prison for the others, 4 years for Roger Hallam, who will serve, it appears, every single day of those 4 years, will not be let out because given an early release as is standard, because he has been assessed as being a danger to the public for being a political activist who refuses to show remorse, who refuses to submit to the regime that has been imposed upon activists through the court system and through the penalties applied. So where does this leave us? What kinds of conclusions and thoughts does this leave us? I think what we've seen is this through the function of the courts, and particularly the higher courts, this intended evacuation of politics from the courtroom. But we can also see the fact that activists themselves, when they're in the courtroom, are developing tactics to try to reintroduce the politics into the courtroom. However, those tactics themselves are always subjected to the wider regime. And we've seen that wider regime of the court move increasingly to a regime of punishment and regime of imprisonment for political activists. So thank you for listening.
Thank you so much, Graeme and Stephen. I'll now pass on to Roxana and Oscar for their presentation.
Thank you so much, Saba, for the invitation to talk today.
Roxana, you have a really bad echo. Or
do I? There may be some background noise because I'm actually in one of the largest cities in the world, in Sao Paulo right now. But there is also an echo, is there?
It's a little bit better now.
Is better? Okay. You probably hear some motorbikes going by and things like that. So apologies in advance. But yeah, thank you for the invitation. So it's a pleasure to be here. I'm going to be fairly brief, and apologies in advance because I will have to leave slightly early to attend another event. But I'm going to give you some broad brush strokes of the situation. And just to say that I'm going to talk a bit about this work that I've been doing with Oscar and also add some analysis from my research in Brazil. So Oscar has been leading this project, the criminalisation and repression of climate and environmental protests at the University of Bristol. So this work really is teamwork, and with other colleagues, Cristina Pantazis, Chris Rossdale, Tia Franco Brotto, who are not here today, but who I'd like to acknowledge for their work as well. I'm going to talk a bit about this report that we published in December, which you can find via this link on the screen, the cresep.blogs.bristol.ac.uk. So Oscar, if you could move us along, thank you. So the report kind of hit some kind of nerve. So, it was picked up by The Guardian and then by several other newspapers around the world, in Brazil, in France, Australia, and other places. We can find links to those articles as well via the website for the project. Oscar, could you move us? Thank you. So I'm going to very briefly just show you some of the highlights from that report. Here it's some of the countries that we were looking at through the data in the study. So from Australia to Brazil, so there are countries in the global north, countries in the global south. And I don't want to focus very much on this, but just to give you an idea. So the next one, thank you, Oscar. Yeah. Of the highlights from this report. So, basically there have been, an increase in the numbers and events of climate protests over the last couple of decades. So we're working with data from ACLED. Oscar, thank you. Can you move us? And also, you can see also this rise in the number and proportion of environmental protests. So this is kind of the context in which some of those acts of criminalization and repression are taking place. So on the one hand, you have this rise in action in terms of climate and environmental protest. Oscar, would you move us? Thank you. But also really what I want to focus in is the kind of response to these events. And here, this is another table from the report, where you see some quite big disparities in the ways in which different countries respond to those protests. So you will notice that in countries such as Australia and the UK, the proportion of arrests are much higher. So if you look at the third column there, you see the proportion of arrests in those countries are much higher than in the rest of the countries in the study. Whereas if you look at the killings column, you see countries such as Brazil and Philippines having much higher numbers of killings of those activists. And here we were working with data from Global Witness. So this is, likely an underestimate of the situation. So, a range of activities essentially that challenge governments and corporate actors are being transformed into crimes, such as, peaceful protests, hunger strikes, non-violent civil disobedience, often on the sites of mega projects or mines, but also grassroots information meetings about the consequences of mining projects are also examples of community actions that are rendered illegal through the criminalization of collective action. So these processes of, we're looking at them as processes of persecution and criminalization that essentially operate to restrict basic democratic conduct. They essentially normalize violence, be it a violence that we can define as symbolic, the labeling of activists as dangerous, as Graeme and Stephen were talking about, or rhetorical or cultural or structural direct forms of violence against political activists. This is all an issue which is associated with a growing context of political authoritarianism. So once someone is labeled as an enemy or as dangerous, equal justice activists or environmental climate activists are often subject to intense surveillance. And this can be by the state, but also state actors, but also non-state actors. So, there is a body of research illustrating this. But also we see that the force of the negative stereotyping goes beyond subtle surveillance of activists' lives and of their actions. This is also a way to legitimize stronger and more violent police responses to activist protests. And it's also a way to criminalize through a range of criminal laws, as well as non-criminal but punitive branches of the law. So, for example, increased uses of administrative fines in the policing of protest. Here you could look at the work of Marotto or Salmini and Di Ronco to illustrate this. But worse yet, this can also legitimize the killing of environmental activists, particularly in the global south. So in the work of Ruggiero, the killing of equal justice activists has been, is illustrated as being legitimized also through an economic argument. So, for example, given that how important corporations are to national economies, or this kind of narrative, or to the well-being of the population, their work should take what it takes to carry on, including violence and death. So this is kind of this narrative or the rhetoric that is used to justify these killings and disappearances. So we're kind of working on with this idea of the repertoire of repression, that actually there are a range of ways in which this repression is manifesting. So in some, in many of those countries, we are seeing the introduction of new anti-protest legislation, but also this kind of creative, and I don't mean creative in a positive way, but it's an expansive use of existing laws and powers, as Graeme and Stephen were also illustrating, to essentially criminalize through the courts. So intensification of policing practices, arrests, surveillance, infiltration of environmental movements, and increased use of physical violence by police or other actors. So in the case of the UK, we see that from the table earlier that those rates of the killings are very low, but in some of the other countries in our study, that's not the case. And alongside this, there is a symbolic violence, this vilification and those criminalizing discourses. Oscar, would you move us along? Thank you.
So this is more to the kind of UK protest part.
Right.
So
yeah, so actually, maybe I'll tell you a little bit about the case of Brazil, because that will maybe be more complementary, since you guys already have a better picture of the UK scenario now, having seen Graeme and Stephen's presentations. So in the case of Brazil, I wrote, I published recently with Ana Di Ronco, where we were focusing on what was happening during the pandemic with activists, environmental activists in Brazil. So, during the pandemic, environmental harm and violations of indigenous rights were essentially being legalized through the law. So, this was happening with several constitutional amendments, which were illustrated in some of the interviews with activists. So I was conducting interviews with activists in Brazil with a team. And so here I'm going to quote an interview extract from someone who works for something called the Indigenous Council. That's the translation. Is known as CIMI, Conselho Indigenista Missionário in Brazil. So I'm so sorry for the background noise. I hope you can't hear it as badly as I can. Anyway, so what he said was, today we're living in a moment in which everything that my generation had is falling down the drain. Cut off like that. We have a legislative that legislates or de-legislates for economic forces that see nature and people only as an investment. What we have today is an impressive volume of amendments to the Constitution, draft amendments to the Constitution, to change all the legislation that defends indigenous rights. So I end quote here. So those constitutional amendments that he refers to, and some of which have eventually been passed, essentially they please the agribusiness lobbies and actors. They erode indigenous and environmental rights that were guaranteed after many years of intense indigenous mobilization. So those activists were explaining that, you know, many right-wing policies were essentially focused, in the case of Brazil, on deregulation agendas that prompted more unrestricted exploitation of natural resources. And this was much like what was documented almost 30 years ago in the work of Andy Rowell in the US. In 1996, he published this book, Green Backlash, where, you know, he documents actually how those policies and those deregulation agendas were very openly promoted. And the same was the case during Bolsonaro's government in Brazil in the pandemic. So, you know, essentially those are practices of free for all that are applied, you know, more specifically to companies invested in mining, drilling, logging, deforestation. And of course, this is going to provoke resistance by social environmental activists. So these struggles really, they are part of this bigger repertoire of contested politics, which, you know, is also the context in which several attacks on those activists, indigenous and social environmental movements are taking place. Those are ongoing processes. They're not necessarily completely new things. However, what we are arguing that we are witnessing is an escalation, intensification, acceleration of those processes. So, you know, this stigmatization, the intimidation, the enactment of legislation that have conservative agendas to either deregulate environmental protections or increase police powers or limit and restrict protest and restrict activism. All of this operate to further privatize land and to promote extractivism, to enforce a free market capitalism without boundaries between militias, policing, anti-environmental organizations. So, you know, ultimately, it's not just the activists, but it's, you know, indigenous, it's all of us that are affected, really. But also, you know, indigenous people's biodiversity, you know, are violated. They're plundered for the profits of multinationals. So, you know, the repression that we are documenting here and we're talking about, you know, occurs, you know, first at the symbolic level through the labeling of activists as a problem, but also through this everyday criminal justice policing levels, through the intimidation and criminalization of those activists. But there are other spheres that are mobilized too, you know, the legal level through the legislative changes that authorize extraction or environmental harm, that make the work of activists harder or sometimes impossible or more challenging. So legislation that increases also police powers to limit their actions and mobilization. There is also the policy level. So, you know, in nexus with those legal changes. So, for example, in the case of Brazil, there were the dissolution of several committees in which activists had seats in and had a space for dialogue with government. Often their seats in those committees were also replaced. So, for example, in the Bolsonaro government, members of the military were invited to take those seats instead of social movement activists. So this was another way to limit the dialogue, restrict those discussions, and change those agendas. But there is also this extrajudicial level, right? So the assistance of militias that intimidate and target activists. So many of those activists that I was speaking with in Brazil were also facing this context. And some of them, for example, were environmental activists in cities like Rio de Janeiro, for example, where they were battling against industries that were, polluting, encroaching on environmental issues within cities as well. And they were hiring militias to intimidate, target, surveil those activists, send them threatening messages. So, this repression of activists is very deeply connected to the ecocidal tendencies of the neoliberal economic system, which prioritizes the wills and the wants of powerful corporations that are backed by the state, while at the same time, they're damaging the environment, encroaching on the rights of the populations and the activists affected by those issues. So, while some of those tendencies have a longer history, they seem to have accelerated with this resulting intensification of repression of activists. So I'll end here and open up. Yeah, thank you so much for listening.
Thank you so much, Roxana, Graeme, Stephen, and Oscar. So I'll wait for the audience to add some questions to the Q&A. I have loads of questions, but I'll start off with one that I think kind of brings some of the themes of both your presentations together. So, starting from the very interesting statement that Graeme and Stephen made in their presentation of thinking of the trial as a productive space, it led me to think about sort of this relationship between repression and the movements themselves, right? So some literature, at least in political science and other disciplines, show that repression or acts of repression actually have a positive impact, positive in the sense of that they strengthen social movements, or you mentioned in relation to the truth-telling slides that you shared in the UK, where it seemed like that was part of the strategy, and the strategy was to kind of not comply and essentially go to prison. So I was kind of curious as to whether, based on the research that you've done, both in the UK, in Brazil, and other parts of the world, to what extent do you think that maybe some of these trials or other forms of criminalization could have provides us some strengthens movements, or do they generally have a tendency to weaken? Based on your understanding. Yeah, I'll start with that, and I'll see what the audience. If any one of you want to address that, that would be.
I'll just come in quickly because actually Chris Rossdale, who's part of Oscar and Roxana's team at Bristol, wrote a book on peace activism, where one of the things that he notes is that activists tend to see trials as either a site of repression or as a site of being a platform and enabling a speech or a wider audience to be reached. And I think we need to be a little bit more, and Chris argues this, I think we need to be a little bit more nuanced about how trials work in that sense. Yes, it does give activists the chance to expand their media footprint. And there was a point, I think, during the Insulate Britain campaign where the whole goal was to try to get 100 activists in prison prior to COP26 and therefore to embarrass the government. That was the strategy behind it. And so Oscar was going to move on to Hallomism. And strategy behind that. So there was a deliberate attempt there to try to create some kind of wider public movement as a response to this form of prosecution, arrest, and imprisonment. But I think, you know, in the longer run, I do think that the governmental legislation and the way that it's been put through the courts has effectively forced the environmental movement, or the climate movement in the UK at least, to change its strategies. We don't know what comes next, but I think certainly to say, as Just Stop Oil did, that, you know, that they were closing down because they'd achieved their goals is kind of a weak argument. And I do think there's a point at which time, energy, and resources are simply exhausted by the strength of the punishment regime that's been put in place for them, and this does have an effect on movements. And so we can see both on one level that there's a space to exploit these opportunities and to try to make public arguments and to try to use the court as a democratic forum, but those points, I think, have been increasingly shut down. And I think it's very hard to see how activists might maintain that attempt to use the courts in that way.
Thank you. Yes, Oscar, go ahead.
Yeah, could I quickly come in on that? So, I mean, if you look at the history of protest and repression, it's obviously far too complex than to say that, you know, it politicizes or the repression succeeds. It's obviously there can be plenty of examples of both. But what's the case is, you know, in the UK, that was certainly one of Extinction Rebellion's and, you know, Roger Hallam's things was that repression will lead to greater politicization. People will be enraged and so on. But I think the dip in the UK is, as I know, building on what Graeme said, like it's a combination of the fact that there weren't enough people to recruit into this kind of high risk kind of activism because of that fewer people believed in it than was the case a few years earlier, alongside with the repression. I mean, it'll be interesting to see what happens with, you know, the Palestine Action thing now, I think, you know, because that's like clearly such a ridiculous move that is being kind of contested daily on the streets and by people and so on. So, you know, we'll see.
Mm-hmm. So thank you. And there's a question from the audience. Someone, Sean Thomas, is asking a question. So it's a question for Graeme and Stephen. Could it be suggested that the approach to public protest, and especially what could be considered Penalver and Katyal property outlaw style of protesting by breaking property law in order to improve law generally, further illustrates how courts have treated property offences generally with considerable expansion of property offences over the past 25 years. So it's a longer question, but would one of you like to address that, please?
Yeah, I think that's one for me, and I know Sean, and that's a very Sean type question. So thank you for that one, Sean. It's an interesting one, and it's an interesting suggestion, and I think I can see that to some extent. I see what you're arguing here, Sean, around, you know, this is a general movement of how the courts think about property. But I think most of the cases we've looked at have not necessarily straight property law type offences, you know, things such as obstructing the highway and public nuisance, interference with national infrastructure, or broader than that. But when we look at the actual property offences, in particular criminal damage is the one that's usually used. Until recently, and I think and some of the more recent decisions, the courts have been a little bit more laid back actually in relation to property offences. So until recently, you could, for instance, argue a lawful excuse that you would believe the owner would have consented to the damage of the property if they'd known of the circumstances. And what a number of activists, and particularly climate groups, did is they argued in court and said, if the owners really knew about the full extent of the climate crisis, and if they realised the full extent of where we are, they would have consented. And that allowed them to basically claim and make those arguments around the climate emergency, the extent of it, the dangers of it, and to put that to the jury, and then basically say to the jury, you know, do you agree that the owner, if they'd known all this, would have consented? But that is one of those defences that has been removed. And I think The other example that comes to mind from our research is the trial of the Coulston Four, which was a straightforward criminal damage trial of the statue of Edward Coulston. And for those of you who don't know Edward Coulston, the pulling down of the statue in Bristol, Coulston was a slave trader and made a great deal of his political and property out of the slave trade. And when his statue was pulled down, the defendants were able to argue, and we'll talk about this when we argue for the integrity principle. They had a number of defences that they were able to put to the jury that the jury ultimately accepted. So one of those defences they argued is that this piece of property was an indecent display and they were preventing crime when they pulled it down. And the defendants, they weren't able to put they wanted to call expert evidence on this and weren't able to put it because the trial judge said that this was in the ordinary experience of the jury. But the trial judge, the defendants wanted to argue that the property was now worth more since it had been pulled down because it was in the M-Shed Museum. It was worth more financially and it was worth more culturally as well. So I think I see the argument, Sean, but I think it's just a little bit more nuanced than that. And I think it depends upon the trial and what's being argued as much as anything else. And I think it's one of our conclusions ultimately is that each trial has a different dynamic in how it's taken place.
Right, thank you. Thanks for that. I think we don't have any questions in the chat. I thought we could perhaps I had a thought when listening to both of your presentation. On one hand, with Graeme and Stephen, you talking very much about the trials and court processes, and in Roxana and Oscar's presentation, there was this kind of discussion on the repertoire of repression and the kind of use of law to essentially repress environmental movements. It just made me think that at the same time, courts are also the site, they are the site which many environmental movements focus on in order to forward their goals. Right? We think of the rights to nature movements, for example, rights for nature in many parts of the world, that and the trials. So I mean. And also in many parts of also the developing world, you see that activists put a great deal of faith in courts to kind of to manage their disputes, over land grabbing or dispossession. Many of these, the main strategy for the activists is actually to have, in combination with protest, of course, is to kind of settle disputes through the court systems. So I was just wondering, it's a very broad question, but kind of how does one think about this dual role that the courts play for environmental movements? On one hand, they're seen as the source through which their movements will gain legitimacy and to forward movement goals, essentially. But on the other hand, we see also this work of repression that courts are actually performing, according to the research that you've done. I just thought we'd just get your reflections on that before we wrap up today's webinar.
Yeah, just to sound that, I mean, look, I think it's interesting. There has been over the last 25, 30 years a strong development of environmental law and environmental civil litigation. And it's clear that has had a number of positive effects, particularly around different norms and standards. But I think, more widely, I think there has to be a major question about whether law can really provide the types of changes that would be required by climate change, to address climate change in a way which might be just or fair. I mean, certainly if David White from Queen Mary were here, he'd be arguing that ecocide, and a lot of people are very focused around an ecocide law, but ecocide simply creates a regime of permission, which would, in other words, outlaw the most egregiously toxic or polluting or harmful effects, whilst enabling those who do more everyday run-of-the-mill cost of business toxic or polluting effects simply to carry on as they were doing. So I think that there are a number, I think, of questions about really whether civic litigation can, I mean, it clearly it's a nuanced picture, and it can produce a number of very positive things, but is it really going to produce the type of systemic changes that would be required to address climate change in a just and equitable way? And I think that the answer to that is probably that it won't.
Oscar, was curious to hear your thoughts on.
Yeah, I mean, I think one of Graeme's early observations of Extinction Rebellion court proceedings were that they didn't use the courtroom at all to, I think this raised your question, didn't really use the courtroom at all as a politicizing kind of space. And then I think they started to, and I think obviously the latter sort of Just Stop Oil ones are. So, and that's kind of interesting. They saw like the arrest as like a politicizing thing, but not the court proceedings. And obviously, you know, courts, it's not like it's live streamed, like you can't see that, but the court, you know, historically the courtroom obviously has been, you know, I can actually, you know, my own dad in 1966 in Peru made a huge scene, a huge theater out of their so he would, you know, involved in land struggles in Peru, a huge theater out of their court proceedings, which had a really big, you know, politicizing effect. So if anything, what we can say about the UK movement is that they went in with this with like not really seeing that as a scene for struggle, but that maybe no, it has been. And I think hopefully, you know, with Palestine Action and so on, it can be, because obviously these are really quickly deteriorating legal, so you know, legal contexts. So there will be certainly a lot of scope to do those challenges there.
Thank you both for answering that question. We have one last question here in the chat, and it's from Pete Gardner, and who thanks both the presenters, and he asks both Stephen, Graeme, Roxana, and Oscar, did you look at the subnational level at all in your cross-national analysis of state responses to protest? In my interview with XR activists, I found considerable differences between legal responses in New South Wales and South Australia at the state level, or police reactions to protest in London and elsewhere in the UK. So whichever one of you would like to have a go at that question.
I can. So yeah. So So the Met has way worse figures than everybody else in the UK. So that's the London Metropolitan Police, but that's partly also because obviously they have the biggest protests and so on. So there are many reasons for that. But I think people who study policing in the UK would probably say that the Met do have a worse reputation when it comes to repressing protests than many others. Obviously, it's not in Australia. It's different, because in Australia you actually have different laws in different parts of the country, and yes, there you see really big differences. So in Australia, you will see states that have a lot of extraction will have more sort of critical infrastructure part of the legislation. That was mentioned, so that's also part of, you know, a lot of the Australian legislation, and the same in the US. So, you know, where there are extractive industries, they will expect a certain kind of protest and protect those extractive industries with certain laws.
Stephen, go ahead.
Yeah, I'm not sure if that question was pointed to us, but I think I wouldn't say the differences are in a sort of subnational in terms of regional, although I mentioned the Coulson 4 trial. I think that was interesting because it was in Bristol, and in a Bristol jury is going to respond to that very differently than the jury outside. But one thing we do definitely see, and we didn't have time to speak about this, was the extent to which different trial judges will respond to a lack of a legal defence in different ways. So, you know, in some high profile have basically said you can't mention the climate crisis, and if you do, it will be a contempt of court and you'll be imprisoned. Some have said you've got 15 minutes to say what you want. You can say what you want, but I'll direct the jury the minute you finish that has no legal effect. And we've also observed trials where judges have just been incredibly laid back and let defendants do what they want and say what they want for as long as they want, but then direct a jury that all of that has no legal effect. So in the trial space, it really depends upon the presiding judge as much as anything else. But I mean, the law, in that sense, how it's then described to the jury, still removes a legal means for defendants to explain why they did. It's more of an extra legal means and more of a, and politics has been smuggled in, I think, in that sense, rather than being central to the trial.
Yeah, just saying on Pete's, and Pete's been very kind. He was also at the Sunflowers trial, and so probably knows more about it than I do. But just to say, in the Insulate Britain campaign of September 2021, when Insulate Britain activists were targeting the M25, police forces reacted in different ways. So Kent police arrested and charged. Hertfordshire police didn't charge anybody. You know, for exactly the same action on the same motorway, just the other side of London. So I think, you know, one of the things that we're dealing with are fragmented police responses because of the organisation of the police forces. And we tend to see, therefore, also says that, you know, that carries through in different ways and perhaps slightly disconnected ways into trial spaces, which is, you know, which is, we would say, is why it's really important to go and observe and see what happens in trials, because actually it can be quite different even for a similar offence for the same type of group.